Hello, everyone. Welcome to our webinar today. My name is Amanda Kay. I'm a program attorney with the National Council of Juvenile and Family Court Judges, and I'm here on behalf of the Resource Center on Domestic Violence, Child Protection and Custody, which is a project of the Family and Youth Services Bureau. And my co-presenter today is Ian Harris.
Hi, everybody. This is Ian Harris from the National Network to End Domestic Violence Safety Net Project. Also as an advisory member for RCDV as well. And we're so happy to have all of you here. There's such a huge turnout, so thanks in advance. And I'm going to turn it back over to Amanda.
Okay. Just briefly, the Resource Center is a special interest resource center funded by the Department of Health and Human Services. While most of the National Council's work, as our title might suggest, involves working with judges and courts, this particular project focuses on a much broader audience, primarily advocates and attorneys and other professionals working with survivors of domestic violence and their children. We provide training and technical assistance on national, regional, state, and local levels in anything that has to do with the intersection of domestic violence and child protection, or domestic violence and child custody, or where all three come together.
And I wanted to spend just a moment to introduce you all to this, for those of you who don't know, to the Safety Net Project at the National Network to End Domestic Violence. At Safety Net, we look at the intersection of technology and domestic violence and provide a variety of services that might be useful to you all, including technical assistance. So we're regularly doing both trainings as well as extensive technical assistance on the phone and sometimes in person around a variety of issues in the way that technology is leveraged within agencies and within court systems to help to more effectively respond to the issues of domestic violence, but also in the ways that technology is misused in domestic violence cases, including some of the information that we'll be providing today. But we would be happy to have to speak with you all further if you have further questions about how technology is being used in your agency, or how you're seeing technology being misused, or also safety ways that technology can be leveraged to increase safety. So we would love to hear from you all about any of those. So I'm gonna move us forward a little bit to what we're trying to work on here today. Actually, you know, the real basis and the growth of this, as Amanda's going to talk about a little bit, of this particular webinar, the growth of it comes from a couple of resources that the Resource Center on Domestic Violence, Child Protection and Custody have started to provide to the field, with a particular emphasis on resources for self-represented litigants. And so what we're going to be doing today is introducing some of those resources and talking about some of those resources. And in that process, identifying some of the barriers that survivors of domestic violence experience, primarily in family court, though not exclusively, and especially looking at those who don't have attorneys. Now, the resources that we will be discussing definitely will be useful for individuals that do have counsel. In fact, we've gotten feedback that they're pretty useful for attorneys as well, who are still familiarizing themselves with some of the finer points of tech evidence. But we think that these are particularly useful when it comes to self-represented litigants. The next piece is to help people to more effectively, and this is what we're hoping you all will take away today, is help to more effectively gather, store, and hopefully admit evidence of tech misuse that will be useful in domestic violence cases. So we're going to be talking a lot about the resources, but also specifically about some tips on how to more effectively gather evidence that has a tech component to it, and how to hopefully get that evidence admitted into court. So that's a little bit about where we're at today. But what I would like to ask, as I'm going to move forward in a moment, we want to hear a little bit about who all of you are. So I'm seeing several hundred people are on the line, and of course we're not going to be able to talk to all of you, though I will note there is a chat feature, and we definitely would love to hear from you. I'm starting to see people roll in a little bit. So here's the first, what is your profession? Are you a private attorney, a nonprofit, nonprofit, though not an attorney. Thank you. Judge, or are you coming in another capacity? In terms of the other capacity, we would love to hear them because I'm seeing a fairly large number of those. If you could give us a little information in the chat box, that would be great. So I'm seeing directors of legal advocacy, director of service. They're going quick. Some probation, great. Therapists, coordinators, okay. Beautiful. So I'm seeing a lot of the results have come in, so I'm going to provide those. What we see here is about 45% are coming from a nonprofit organization, though not necessarily in a legal capacity, not necessarily as an attorney. About 35%, though that's changing, looks like our not an attorney nonprofit folks are going up a little bit, but that's definitely the majority. There are a good number of attorneys as well, and with the attorney population, seems like the majority of those are coming from nonprofit organizations. Perfect. So now what I'd love to hear from you all is, for those who are attorneys or working in the legal capacity, in what capacity are you mainly dealing with? Now, if you're not an attorney, because I saw a fairly large number, what type of cases are you generally assisting survivors of domestic violence with? Or is it family, criminal in the defense context, or criminal in the prosecution context, other types of civil, immigration, or something else? And like we asked before, if it is something other, though I'm not seeing anything pop up yet, please do let us know a little bit about what that is, what you're working on in the chat box. I'll give you just a moment to go through that. And thank you all so much at this point for your participation. I get to see the numbers on my end, and they're quite good. So thank you all for participating. I'm seeing crime victim advocates for Stop Domestic Violence Program, working on protective orders, general legal advocacy, law enforcement. Great, I'm glad we have some law enforcement folks here. Injunctive work, Title IX issues, so some campus-based stuff, I assume. Some transitional housing. Great. So we really have a nice mix of people here, and I wish we had time to talk to all of you about what things are going to be most interesting to you, but we really do appreciate you making your way out. A couple more questions so we can know a little bit more about you. Sorry. There we go. So how often are you seeing tech misuse? This term tech misuse, just to note it, we're talking about a variety of different types of behavior or misbehavior. It may be something like sending in a harassing or abusive text message, or tracking, locating, stalking, identity theft, fraud, a whole variety of different things. So I would encourage you, when you're thinking about your responses to this question, to be as broad as possible, to fit in whatever way you see tech misuse as being defined. Cool. So right now I'm seeing that a fairly large majority are suggesting that they oftentimes are seeing these issues pop up. Some people have almost every case. A fairly large or decent number say sometimes, though it seems really that, and this is quite reflective, we actually, the National Network, and in conjunction with NCJ, FCJ, We last year went through a process of seeking out information from judges and survivors and court personnel, attorneys, and advocates about how they were seeing technology and the misuse of technology playing out within legal cases and domestic violence cases, and these are really similar types of numbers to what we were seeing back then. Definitely the majority said often, though a fair number were saying that they were seeing in almost every single case, which I think is very much similar to my own personal experience when it comes to technology. My background is as a civil legal services attorney representing domestic violence survivors in a variety of family and immigration and divorce matters. And what I started to see as time progressed is that more and more cases really did have some sort of tech component. The real question was just whether or not I asked the questions sufficient enough to get to them. Beautiful. Well, thank you all. I'm going to have one more question, and then we're going to move forward. So last question is this: which of these technology issues have you seen with the individuals that you're working with? So which tech issues? Location or GPS tracking, monitoring phone or computer activity, sharing nude or sexual images without consent, also known as revenge porn, unwanted or abusive text messages, unwanted or abusive email messages, unwanted or abusive social media messages or images, or, of course, other. And as always, if you do say something in the other, we would love to hear a little bit about that in the chat box. I'm seeing identity theft and GPS location apps. Stalking is a major issue, and violations of CPOs or civil protective orders. So I will broadcast the results in just a moment. I see a couple of people are still finishing up, but what I do note already in your responses is that the numbers suggest that you're seeing a lot of different types within the cases. So I'm going to broadcast these to you all. You should be able to see at this point, but it looks like a very large percentage actually throughout are seeing these types of a wide array of types of abusive behavior. The highest one is unwanted or abusive text messages. The next looks like unwanted or abusive social media messages. That is extremely spot on from what we have recently, what we've learned from a variety of different communities that are interfacing with domestic violence survivors, that those two issues are by and large the most consistent and the largest issues. So text messages and social media posts, definitely the biggest issue. We're going to talk a decent amount about those and some of the processes of how to get access to that in this webinar, and hopefully you'll leave with a better understanding of what to do with those. I will say one of the feedback that, as we were seeking this feedback and noted that there was a very high percentage of text messages and social media postings that were causing, or at least an issue in domestic violence cases. While obviously we want to stop that behavior, there is something slightly hopeful about it, which is that this type of evidence, that type of misbehavior, many courts that we spoke to are regularly seeing those issues and feel like they are able to effectively respond to a variety of them, which is of course we want the behavior to stop, but there is something about the fact that we do actually have a good amount of case law, a good amount of experience across the nation in dealing with those issues, which is good. Some of the higher levels of technology can be really very, very difficult to get access to admit into court, and so having these particular types of technology as the most common at least gives us a foothold to effectively to start to respond. I did want to note from the chat box that many people were saying that that almost all of these were issues in the case. That they were seeing batterers who were spoofing or blocking phone numbers. So spoofing, just to be clear, is the process of essentially hiding your identifying information. so that the other person isn't able to see who's calling, who's emailing, or has a misunderstanding of who's calling or emailing or sending some other communication. Seeing repeated, yeah, so that's spoofing calls definitely popping up quite a bit. I would imagine that almost everybody on this webinar has in recent weeks received some call on their cell phone in which the first 6 digits are the exact same as your phone number, and the last 4 digits are slightly smaller. Are slightly different. So first 6 digits the same, last 4 digits different, and that's actually a really good example of spoofing. So and a lot of people who are trying to sell things or commit fraud in a variety of ways have started to use spoofing as a tactic because they realize that when you put a number that looks very similar to the person who's answering the phone, their telephone number, that people are much more likely to answer that number because they think it's a neighbor or somebody in their local community. So one example of spoofing. I'm seeing the use of internet phone numbers, which is in some ways also another way of spoofing. So for those, just so we're all on the same page, what that means, there's a variety of ways for people to get access to free telephone numbers, or paid in some cases, but many people are able to acquire them for free under Google Voice or other types of internet phone services that will allow you to basically use your cell phone, make calls from your cell phone, but using a different number. And that's allowed a number of people to basically pretty effectively hide their identity, and has come up in a number of cases related to violations of civil protection orders, which I saw popping up a lot. Great. We're going to keep moving on. Thank you all for responding. I'm going to pass it over to Amanda, and then we'll get into evidence a little bit later.
Okay. Just to kind of provide a starting point, one question that we wanted to just briefly address is why we decided to focus on help for self-represented litigants. It isn't something that either the Resource Center or the National Council has traditionally done a whole lot about. We've previously been focused on how to help courts better respond to the needs of self-represented litigants, but not so much directly helping self-represented litigants. But what we were finding from a lot of our other projects, as well as calls that we get on an 800 line that is part of the Resource Center, most of those calls are from survivors who are seeking help in their cases, and most of the time it's in their custody cases, not so much the protection orders. It seems like there's a fairly good system of assistance for and support for the protection order process, but not so much in family court. Certainly what we're talking about today can be used in either type of proceeding as well as others. But what we were hearing was that, and particularly for today's topic, why we decided to do a few resources on evidence, is we were hearing from both our judges that they really want to help the survivors, but they can only do so much depending on what evidence is introduced and what evidence is properly before them. And if they found themselves really frustrated when a survivor came in that they just had a gut feeling really needed help, but there wasn't any evidence presented of the abuse or of other forms of relief that the survivor might be asking for, and so that their hands were tied. At the same time, on the 800 line, we were hearing from survivors that they had no clue what to do. They didn't know what the court procedures were. They didn't know what evidence was, and they didn't know what was expected of them when they stepped into court on their own behalf without counsel. And so we decided, after looking around to seeing, were there resources already out there that we could refer folks to, we didn't find as much as we were hoping for. Again, there was a lot on the protection order side, and then there was a lot on family court and family law cases without domestic violence, but there wasn't a whole lot on the intersection where you're going to have a custody case that has domestic violence overlays, and that makes a huge difference in the case. And so that's why we started with these resources. Just some quick background, and many of you are probably already familiar with this. Studies have shown that 70 to 85% of litigants in family court are self-represented. In some courts, that's as high as 90%. In some of these studies, and there's two that I'm primarily referencing. One is here in the States and specific to family court by the Honoring Families Initiative. It's called Cases Without Counsel. And if you Google that, you'll find it, or if you want, I can post a link to the final report in the chat box in just a bit. And then that was actually based on a Canadian study that was broader and looked into self-represented litigants in all courts. But a finding that was common to both studies was that virtually all self-represented litigants would have lawyers if they could, and cite financial reasons as the primary reason why they didn't have counsel. Either they had their own lack of funds to pay private counsel, or their legal aid agency in their area didn't have sufficient resources to represent them. They also said that they find court confusing and stressful and they need help. And while many litigants were able to successfully resolve simpler matters, complex matters posed more of a challenge, and they frequently found themselves at a complete loss in how to handle those. When you then look at self-represented survivors, all of these challenges are magnified. It's pretty rare that you have a domestic violence situation where there isn't some form of financial abuse. Most survivors who are attempting to leave the relationship are experiencing financial stress and financial need, and so that is exacerbated for them. The stress level, again, just this confusing system is stressful, but then you add on layers of trauma, trying to deal with children who may have also suffered trauma. There's so much more that to be faced, and then trying to handle a court case on top of it where you have no clue what's going on just increases it exponentially. And then the complexity. You know, any family custody case, and again, that's kind of the default that I'm starting with, has complex issues. If you don't have an agreement, then you've got complexity. But when you add domestic violence to it, again, that ramps it up. You've got the issues of what type of violence it was. You've got to present evidence of the violence. You have to present information on how the violence affects things like the custody analysis under your state's best interest factors, because usually it affects, you know, more than just the presence of domestic violence. It can change how some of the other factors manifest. But in order to convey that to the court, you have to be able to understand it, and that both the legal issues and kind of the emotional and the child developmental issues even. And that's all very difficult, again, especially when you're already under tremendous amount of stress and trauma. So based on what we were hearing, one area that we definitely wanted to focus on was evidence. And so we came up with two of what we're calling the self-represented litigant series. You'll see later in the presentation we've got a few others. But these are the two that we're mentioning today. The first one that we published last year, 10 Steps for Presenting Evidence in Court, that just is a step-by-step guide in how to gather, how to organize, and then some tips on how to present and where you can get additional help and in learning how to present evidence in your case. And we did a webinar last year specifically on this one, so I'm not going to go into too much detail today. I'm posting the link to the webinar in the chat if you want to see the more thorough step-by-step webinar devoted to the 10 steps for presenting evidence in court. The one that we're primarily going to focus on today is one that Ian and others at the NNEDB Safety Net did, which is how to gather technology abuse evidence for court. And we'll be moving to that fairly quickly. Both of these resources are in your materials box, the PDFs there, and can be downloaded. And you can make as many copies as you'd like and distribute them. There's no restrictions on that. If you want hard copies of the 10 Steps Guide, we have those, and you can request them from us. The How to Gather technology is not yet printed. We hope to have that done by early fall, but in the meantime, you're free to download and print as many as you'd like. So first issue is, what is evidence? And evidence is just information, and it pretty much comes into court one of two ways. Testimony, which is people coming in and talking, witnesses. It can be the parties or it can be other people with knowledge of information that's relevant to the case. And then exhibits, which can be things like emails, texts, legal document, contracts, leases showing who's on a lease and who's not. It could even be broken furniture, providing evidence of a violent incident. So it's basically anything that comes into court will fall into one of these two categories. What the 10 Steps Guide is just identifies 10 steps toward getting your evidence ready and then being ready to present it. First is learning what help is available. Each community's resources are different, so we find it provides some information on where you can find out what help is available in your area. List what you need to show the court. That'll depend on what you're asking for and the law in your state, but it gives some tips for things to look for. Identify potential evidence. It encourages litigants to be creative in how they think about evidence, thinking of witnesses who may have seen something or heard something, and other evidence that might be helpful to the case. Select the best evidence that supports your case. So the pool of potential evidence is probably huge, but you're only going to have a limited amount of time in court, and so you want to pick what is the most reliable and provides the best description and information to the court to provide a good understanding of what's happened in your family and why you should get the relief you're asking for. And then again talks about making sure the evidence is reliable, and there's court rules that express preferences for certain types of evidence. Ian will be talking a little bit about some of those in specific reference to tech evidence in a little while. And then the last steps, review how to present exhibits, and we're going to give you an example of that in just a minute. Gather all the evidence that you might have, prepare any exhibits. Usually courts require anybody who's going to seek to admit exhibits to follow a certain format, and so part of what the guide talks about is how to find out what your court's format is and then make sure that you are prepared to submit your evidence in that form so that it's got a better chance of being accepted and admitted by the court. Organize your presentation. Particularly for survivors who are struggling with trauma, getting some help with this setup can be of great help because a lot of times the brain and the memory is not working, chronologically to tell a story in a linear fashion. And so having some help to organize the presentation and having an outline to follow when you go in and not just having to go off the cuff can be a huge support in trying to present a case. And then we encourage, to the extent that they have time and that the court will allow it, watch a hearing so you can see what happens, and then practice your own presentation so that you get a certain comfort level with what you're going to be doing. So here's an example of what we did in the guide was we provided scripts for some of the most common types of evidence that might be thought to be admitted. So here's one that provides a good jumping off point to the rest of the webinar, and a text message. You ask clerk to mark a printed copy or a photograph or a transcript. You show it to the other party and the judge. You explain that it's a text message, explain whether you sent or received it, and identify the phone number. And explain how you obtained the version that you're providing to the court, whether you printed it, whether you transcribed it, and testify that it's an accurate copy, and then ask the judge to admit it. And then once it's admitted, you can use it to argue all the rest of what you're asking for from the court. One thing that the 10 Steps Guide, though, assumed was that you already had that text message reproduced in a way that was admissible. We realized that that wasn't the case, and so that was one reason for doing the next step, which is how to gather tech abuse evidence in court, SRL Guide. And that is where Ian starts.
Great. Thanks, Amanda. So I want to just say that there is what we've learned across the country, and this is definitely my experience as well. Oftentimes, particularly in the context of family court cases, it's not uncommon to have a pretty informal process. And the informal process can lead sometimes to courts accepting a whole variety of evidence that they then determine a little bit later whether, not whether it's admissible or not, but rather how much weight they're going to give it. And what we tell people kind of from the beginning is that just if we're completely forthright, many courts, even courts that you go to fairly regularly, may accept a variety of pieces of evidence without actually laying as intricate a foundation as is probably evidentiarily required. And so, courts oftentimes accept things that, if further scrutinized, wouldn't necessarily come in. But it's really important to prepare as if, you're going to have to hit all of those evidentiary hurdles around admissibility, because what we have gotten some good feedback on, and I've seen it play out in court, that, you have a case that has a piece of evidence, let's say a text message, and 99 times out of 100, maybe the court will just accept it, either read the text message off of the device itself and read it into the record, or accept fairly basic images of the text message. And in many cases, that is definitely going to suffice. Until you get to that 100th case in which somebody pushes back against it and suggests that they didn't actually send it, or pushes against some other evidentiary foundation, and then you can get really stuck in court. And I've seen it happen again in real life, and it's a pretty awful situation for an attorney, particularly if the person needs the relief that you're looking for. So I'm going to get in a little bit into different pieces of tech evidence. We talked about that. Sorry, I'm going to move. Great. So I have kind of made a promise to one of my former clients, and so I want to stick to that promise about technology. So we're going to be discussing in a moment some of the ways that technology is misused, and some of the ways that technology has been really used as a tool of abuse in order to track, to surveil, to really harass people's lives. But I think that's not the complete story to technology, and so I wanted to note that. I had a case not a couple of years ago, and I was representing this client in a civil order protection case and in a case, in a custody case as well. So in New York City, where I practiced, we have integrated domestic violence courts where both criminal and civil matters are able to be heard in front of the same judge. It's a pretty nice process, hoping that some of you also have a similar process within your jurisdictions. So there was a criminal court case that was being handled by New York State, by a prosecutor, and then I was dealing with the civil components. I was working on the case for about a year and a half, and in that time, thankfully, we were able to get the client out of where they were living jointly, and the actual physical violence during that time had ceased. We had a pretty effective process for pickup and drop off and for custody, and basically for the visitation schedule. We had something set up that they didn't have to see each other. that my client was safe, but that they both also knew when the pickup and drop-off was going to be consistently, so that it didn't require a whole lot of communication. So despite that fact, there was continuing violations of the order of protection, mainly through text messages. There was actually the person also hacked into the Facebook account, so was able to somehow get bypass the password on the account and was able to get access to the Facebook account. So those things were happening, but otherwise, they're actually, the case was sort of calming down. Unfortunately, when I spoke with my client about making sure that the police knew about these violations through text messages, when she would go to the police precinct, they routinely sort of pushed her away, told her that they couldn't do anything about it. In some cases, because the text messages were anonymous. In other cases, they just said that they didn't rise to the requisite severity level. Either way, they refused to even write out reports that these things were happening, which was causing a lot of issues for the client, as you can assume. Because this continued to happen, the prosecutor on the case, who was really great and very focused on getting justice for the client and was really like domestic violence focused, was kind of pushing the client to get rid of her phone, to change her phone number. And the thought there was, sort of obvious that this was the one mechanism in which they could continue to exert some control, and was continuing to do so and wasn't really having any response from the judicial system in any real way. It was all kind of slow churning, and she wasn't getting any relief, and so she suggested that maybe that might be a good idea. Now, obviously, we always want to be survivor-centered, and we want to hear what survivors need, but I will be completely forthright with you all that I really wondered if that was a good idea in this particular case, because we had created these other systems that would make it so that we had some other safety mechanisms in place. I talked to the client. Ultimately, the client decided that she didn't want to get rid of her phone number, and that was in part because she didn't feel like she wanted to give up all of her contacts and all of the things that were important to her in her life. It meant a lot to her, but it also was in large part, and probably even more importantly for this particular client, was that she didn't want to. She wanted to know where his mind was. She wanted to know where his danger levels were, and she thought that she could more effectively gauge that by seeing these text messages. And so, I had a really long conversation with the prosecutor, and we ultimately decided, the client decided that she didn't want to do it, so I fought for her, and she ultimately didn't do it. Now, about a year and a half into this case, I was in court, and we got my client had got a text message the night before court, and in that text message was a picture, and the picture had a hand, and on that hand there was a little tattoo, which we were able to identify as her ex's tattoo, and the hand was holding a gun. And so, of course, that's extremely concerning, and we let the judge know. The judge told the prosecutor, that to make sure that he was arrested. We were concerned that that wasn't going to happen, not because the prosecutor wasn't going to do it, but because the police hadn't necessarily been that helpful in this particular case. And so we made a really extensive safety plan that would keep her out of the house for 2 days until we could get back into court. I got the call the next day. This client was a college student, and she had a small child, so her schedule was very rigid. She arrived and left at the same time every single day. I got a call about 10 minutes after she was supposed to get home, and she wasn't there, thankfully, because we had safety planned around it. Her ex came to her home, and he pulled out that same gun. He asked for her, and when she said that, when her family said that she wasn't home, he killed himself in front of her entire family. it was a really awful scene, and something that I will sort of never forget, as well as a lot of other people who were on this case. But what I took from that is I had been working on domestic violence cases for a long time at that point, and I also was specifically working on tech-related issues. And the truth is, I didn't catch it. If you had have asked me whether or not that was the case in which there would be a potential murder, suicide, it's not what I saw coming in this particular case at all. But I did leave that with an understanding that technology absolutely, her decision to maintain her technology was the thing that kept her from being killed that day. We actually later found out that he told two people on his way over that he was going to, that he had a full clip in the gun and that he was going to kill her and that he was going to kill himself. And so the fact that we received this text message alerting us to the danger was the one thing that saved this client's life. And so, while technology can be misused, and of course the sending of that photo was a misuse for sure, it also can be the thing that can really provide protection to people. And so getting rid of technology is really not the answer, even if the opportunities for abusive behavior are greatly increased in some cases. Okay, so now that you all have heard that and are feeling, I'm sure, upset, because it was a very upsetting situation, let's talk a little bit about what we can do when that circumstance arises. So in terms of gathering tech evidence, I really, really would love for you all, and I'm really encouraging and hoping that you will, in fact, go and download these resources that we referred to, because I think there's actually some really good information, and it's going to expand upon, at least in part, the gathering aspect of the technologies that we talked about. But when gathering tech evidence, there's really a couple of different considerations. We have a lot of people who, I saw a lot of people who are serving as advocates, who are working at nonprofits on domestic violence issues, but who are not necessarily attorneys. I do want to say for everybody here that it's really important to be thoughtful about the gathering process and who, in fact, is doing it. So what I mean by that is many clients are going to come in and they're going to say, or many survivors, whether they're clients or not, are going to come in and they're going to have some evidence, because so frequently there's a tech component. They're frequently going to have some evidence, and people who are experiencing violence and who are seeking out assistance oftentimes they're in a crisis mode, right? They don't have all the resources that they probably need at that moment, and including things like printers and access readily to safe computers. So it becomes this situation where people will ask you to assist in that process, and it is okay to assist with the process of gathering evidence, though I will say you want to be very, very thoughtful about not making it a situation in which you become the link that a court would need in order to ensure that this particular type of evidence is valid and something that can be admissible into court. So you don't ever want to get into a situation where you are the holder of the key. Now, if you're the attorney on the case, you of course don't want to have that situation occur, because you don't want to have to become a witness in your own case, because you can't represent somebody if you're a witness in the case. So that's a huge negative impact for the client. But if you're not an attorney on the case and instead you're working with this survivor in a different capacity, you also want to be really thoughtful about it too, because having a court require you, being subpoenaed by the other party or by the court itself, to come and testify about this evidence in order to let the court know that it's actually valid is an awful place to be put into. One, because many programs have confidentiality requirements and other grant requirements and under federal law, but also your ability to maintain private information is one of the most key and essential roles that anyone who's working with a survivor has. So I do want to note, be really thoughtful about that process. When thinking through and helping self-represented litigants in this process, but also in helping with clients, here's the things you want to think about. So first and foremost, can whatever you're getting prove the other person wrong, or prove the person that you're supporting that they are in fact right? The next, you're going to want to think through, what is the evidence? And when I say what is the evidence, that actually is a shockingly complicated question. And so one example that I'd like to give you is when most of us here, I don't want to assume about everybody, but most of us are going to have a smartphone. That's statistically accurate. And on that smartphone, you're going to go through and you're going to look at your text messages or your messaging, and whether it's Apple or an Android-based or a variety of other companies. But there's going to be a place where you get messages, and these messages, they oftentimes come from many different places, and what place they come from has a huge impact on what the evidence might be. So as an example, I have an iPhone, and if a non-iPhone user, so an Android user or somebody else who does not have an iPhone, sends me a message, that message is going to be sent as a text message, unless they go through some other instant messaging app. But the normal function of sending from one phone to another across your cell service, AT&T or Verizon or something similar to that, is a text message. And a text message is something that lives in two places. So it lives on the device, and it lives with the company that serves as the conduit in sending that. Now, that's really important because where that evidence is going to be saved is going to be very different if it is a text message versus an instant message. So an instant message is something that's sent over the internet. It can be sent through a variety of different services. There are apps such as WhatsApp that send instant messages. There's also programs like iMessage, which is something that's built into the iPhone that sends an instant message. Now, if somebody sends from an iPhone to my iPhone a message, it's going to send as an iMessage, and that's as an instant message versus a text message. The unfortunate part is that it's going to go to the same place. It's going to look the same. There's not going to be a whole lot different about it other than the fact that where that evidence is saved is drastically different. Okay? So where that information is going to be saved is going to be, for an instant message sent through iMessage, is going to be as Apple, whereas a text message is going to be saved, let's say, at Verizon. Now, Verizon and all the other telephone companies, they tend to not save actual text of messages for any real period of time. We've heard that some hold that information for a couple of days, but for the most part, it's going to be deleted almost immediately because people send so many text messages. Now, what will be in that with the company, let's say Verizon will have that information and records that something was sent and something was received, but they won't have the actual information about what was sent. They won't have the actual text, the narrative of that message. And once that's deleted off the phone, it's hard to ever get that back. Now that's distinct from an instant message where it's going to be potentially saved in numerous places on the phone, maybe in iCloud, which is the cloud-based service that allows for backup. It may be saved with Apple. So there's a number of different places where that information might be saved that it might be accessible for. And every piece of evidence, we need to think through the same sort of process. So what is it? Meaning, like, what is the actual function? A text message is some sort of message, whether it's video, audio, or an actual text. It could be visual, like an emoji, that's sent over a cellular network, right? Versus an instant message, which is different. So by understanding what those things are, we can also find out where they're saved. Now, the saved piece of it becomes really, really important. So, for example, if something is saved with Verizon, again, you're going to be limited in which you can get access to, like I referred to earlier. However, the good news is that if the information is still saved, a person can oftentimes get that from a company themselves. They can make a request and they can get it. That's quite distinct from, let's say, a Google, we'll stick with Apple because we were using that. So in the Apple context, Apple is not generally going to respond to non-criminal court subpoenas. So Apple will respond to appropriately situated law enforcement criminal subpoenas. Apple will not respond to subpoenas requesting information on civil cases because there's a variety of reasons. The biggest one being there's federal law that basically requires them to respond in the law enforcement context and not otherwise. So I did see a question about a subpoena for Gmail evidence. I'll be honest, there are many, it is oftentimes it is very unlikely that a subpoena to get Gmail evidence is going to be successful in a civil case. It's more likely to be successful if it's a law enforcement-based subpoena and it's a criminal court subpoena, but in a civil context, it's pretty unlikely. So I know that there was a question, and I'm not sure which one, which context, whether criminal or civil, that's coming from. However, I will note that it is very, very difficult to get responses in, say, a civil stalking case, like I just saw from Gmail. It sometimes happens, but it's pretty unlikely. So the answer is it takes a very, very long time, maybe too long. Now, sometimes people can get access to their own information about things that they've sent, but really what we're dealing with, unfortunately, across the nation with most of the large tech companies is they are increasingly creating access points so that people can download their own information, so that they can get access to their own information because, unfortunately, they're generally not going to be responding to those. And I will say, even though as a former civil legal services attorney, I really want access to that stuff, and in a ton of cases, I did have a chance to speak to some of the larger tech companies about what that actually means, and I asked them how much it costs for them to respond to criminal court subpoenas, and they said about $10 million a year. I asked them what it would cost to respond to civil, and they suggested that it's somewhere around 10 times that amount. So that it could be up to $100 million to respond to it. We're talking about a lot of requests coming from all over the place, and there really is some serious limitations in the accessibility of that. Okay, so once we've thought through some of those things, tech evidence itself is what's called electronically stored information, and ESI, or electronically stored information, is really information that best lives its best life. Now, I think we all are talking about what is our best life, and truthfully, ESI's best life nowadays is in a digital format, and the reason for that is it is compiled of two things. It's compiled of the thing that you see that's visually on the screen, but then it also has all the other information, which is the metadata, and that metadata, it gives a whole backstory that you don't initially see unless you have some sort of knowledge and know-how about how to get access to it. Sometimes it requires other types of access points beyond just what a person is likely to be able to do with the device itself. But that metadata tells a very long story that can be really, really important. So the unfortunate reality is that our court system has not necessarily, or at least most courts, have not caught up with the way that technology has necessarily changed. And so what it means is that the majority of tech evidence is going to have the tech piece of it sort of stripped out, and you're going to take something that really does best live online or in a digital format, and you're going to turn it into a hard copy, oftentimes, a printout, a screenshot, or something to that effect. Now, there are some obvious benefits to that. You can put a screenshot into a court record much more effectively than you can into say like an audio recording. It's hard to keep that in the record for any substantial period of time, mainly because there are many different formats for audio recordings. Those formats change. They require specific devices to play them. There's a lot of issues to that effect. So a lot of things end up turning into this paper copy, which, again, for ease is helpful, but we lose some things as well in that process. In going through that, here's the things that I would suggest, particularly because I know we have a lot of non-attorneys, in helping people to document their abuse. And I think that that's really the way to think about it, is how do you help people to effectively document? You definitely do want to help them you definitely do want to help them respond to log as much as possible the patterns of harassment and stalking behavior, the patterns of misuse. I have had numerous cases, just as an example, in which we receive, the client received, endless flows of anonymous postings, anonymous calls, anonymous text messages, things that can oftentimes be very, very hard to track with somebody. And, despite the fact that we weren't able to, without, beyond a shadow of a doubt, prove that a specific person, sent this. Now, could we have done it if we were able to get a forensic analysis and evaluation of a device? Probably we could have. But that's very expensive and oftentimes not going to be available, particularly in the legal services context. So what we did is we did really extensive analysis of the patterns of harassment. So the client would take down the time, the way that a call would come in, meaning like how many rings, how consistently, how many times back to back. And by looking at that information, I've had numerous cases where we've been able to prove that a person was anonymously communicating inappropriately, because we were able to show the times that they were calling corresponded to times where the person was available, and that the times that they were not calling corresponded to times they weren't available. And other types of circumstantial evidence, and that happens in a lot of cases. So keeping a good log is a great idea. We have access on our website, techsafety.org. That's techsafety.org. We have access to a stalking log if you are interested in looking through it. Help people to take screenshots or photographs. That all can be useful. Let people know well in advance what you need from them and what you don't need from them. Because I will tell you, I've made the mistake numerous times that, I can't assume that people understand what they are going to need in court, right? I have clients that come to me, all the time with printouts, screenshots that they've printed out of an abusive text message, for example. And what do those clients oftentimes do? They bring in a screenshot of the particular message that they found to be the most inappropriate, the most abusive, the most harassing. And that makes sense to me. That's a totally understandable choice and why they would do that. Unfortunately, courts don't oftentimes want just the worst. They want an entire conversation. They want to see the context of the communication, because it's so easy to misrepresent what somebody is saying in a text message. So what I would really, suggest for people is, let them know, let the survivors know in a very clear way what you're looking for and how much you want them to maintain. And then to think through, all right, so if, let's say, we want text messages, and we want text messages that are entire conversations and that have something that either demonstrates a particularly abusive behavior or gives some context to something that is at issue in the case, that you want it as screenshots, that you want those screenshots to have date and timestamps. And just so on that particular issue, date and timestamps, so you all know, they hide that information on most text messaging programs on Apple and Android. They hide it, although it's there. So if you go to your screen, you open up a text message, you're going to see possibly a date that it was sent, and then it's going to be basically nothing. What you can do afterwards, and you basically take your finger on the right side of the screen, hold it there, and then just sort of pull while still touching the screen to the left. So go from the right to the left, and what you'll see on the text message is that the timestamps will emerge there. Taking screenshots with those timestamps can be incredibly useful in cases, and so I would suggest that. So the things you're asking for: full conversations, entire screenshots that have date and timestamps whenever possible, and as much identifying information as possible in ways that have not been manipulated. All really useful, and you're going to want to tell people that in advance. So some things in helping survivors work through this. The resources that we've provided also will help walk through that process, and so this is sort of helping in supplementary information to that, so please do take a look through that. So first and foremost, teaching people how to work, teaching the things that you need. So you let them know all of the things that are going to be helpful, if at all possible. I want to highlight this very last point, which is around making sure that, agency is really effective. Letting people know that they can really impact their case can really be useful in cases. And it's been helpful for me, both in terms of getting effective evidence, but it's also been helpful in learning a little humility at times. So I'll give you one example. I had a client a couple of years back, and she continuously was receiving these anonymous postings online, and these anonymous postings, were having a really hard time getting access to them because they were on Facebook, and again, Facebook was not going to respond to a civil court subpoena to get this information, and so we had to find another mechanism of finding out who was sending that. And I was really racking my brain, and I was failing to come up with an option and an understanding. And then the client was able and alerted me to the fact that when this person did postings, their postings did something very interesting. They would write a sentence, they would then do a space, they'd put a period, they'd put another space, and then they'd write another sentence. So they had this extra space in front of the period, which is a weird, kind of a strange way to write, and pretty unusual. And so that little piece of information, that little signature of this person, combined with some of the things they said, some of the times that they sent them, all of that stuff combined to us, winning in court and being able to prove to the court that this was this person continuing to demonstrate abusive behavior. And so something quite innocuous can end up being really, really important in those cases. And there's no one better in many ways than the survivor to be able to, unravel some of these interesting quirks that they've become accustomed to, but that they know. So tapping their knowledge can be a really, really good resource. Make sure that you know early about the technology that people are using, right? Know what their data plans are. Know whether they're, what company they're using with their cell phones, what type of communication tool they email with. All of that information is incredibly useful in cases to know in advance, because not only are you going to know where to look, but you're going to know how quickly you have to look for that information in order to get it before it possibly gets deleted or destroyed. It also can hopefully help you think through a little bit with the individuals you're working with, how they can increase their own security and online privacy and safety, which is, we also suggest thinking through, because really any piece of evidence that we're discussing today becomes incredibly ineffective if, in fact, the information has been lost because somebody, the abusive party, was able to access it because the person didn't have proper privacy and security functions within their own devices. So, online security really should be considered as a piece of your evidentiary investigation, because it's about securing evidence. Great. One thing that I don't see very often, and I think is really important, it's really good to know, first and foremost, what your client can get access to, mainly because, like I said, subpoenas don't always work in the civil context, and you oftentimes, before you send a subpoena, even if it's successful, you're going to want to know what is in that, what you're going to get a response on to some extent from that subpoena, because if you're getting a court-signed subpoena, you're also going to have to give it to the other side. And, giving it to the other side, I'm not suggesting you want to necessarily hide evidence, but what you do want to protect is information that's not relevant to the case that also might be included in there, and it can be pretty hard to do that if you don't know what you're protecting from the beginning. So we definitely suggest identifying what the client can get access to, whether they can get it without having to do a subpoena, and what the other party is going to have access to, because you don't want a situation where the other party has access to something that you don't necessarily know about and that they blindside you in court. Cool. The most common way that technology is transferred from a device to the courtroom is through a screenshot. There's multiple different ways to do screenshots. Apple computers in particular have a whole variety of ways. For those who haven't done it, we do give a pretty good explanation about screenshots in the resource and some of the ideas on what might make the particular piece of evidence a little bit more effective. So please do see that. This is how you take a screenshot. This is the button that you push when you're taking a screenshot on a non-Apple computer. So a PC, you're going to push that, and then really nothing is going to happen. You're going to have to open up another program like Word or Paint or something like that and paste the information, and then you're going to get a really beautiful picture of everything that was on the screen. Here's information about how to do that on a Mac, so on an Apple computer. Here's some ways that you're going to do it on mobile devices, depending upon which version you have. So what we say in the resource is, do a quick online search and say how to take a screenshot on, and then fill in whatever device. That way you don't have to know how to take a screenshot on every single device out there for every single client. You just need to know enough to help them to get the information. And there is tons of videos online on basically almost every device that will tell you how to work that device, including how to take screenshots and where those screenshots live. Cool. So I'm going to get into some more tech basics, tech evidence basics in a moment. I did see that one commenter said that with Windows 10 and above, it's the FN and the end button as an example. So there might be different ways to take it on different devices, to take screenshots on different devices, and it's important to just do a quick search that will help you, get the most relevant information. Are there any questions? I do want to, I want to encourage people to continue to use the chat box if you do have questions, and I will do my best to get to them. So just know that is still open, and we are in fact reading them. So with the tech evidence basics, tech evidence is the same as all evidence, that there's going to be a process of laying a foundation, and that foundation is basically going to be comprised of all of these things. Is the evidence relevant? If it's relevant, is it authentic? If it's going to be offered for the truth, right? So if you're trying to say, like, whatever is said here is actually truth, is there hearsay, and is there a hearsay exception? Is the evidence original or a duplicate? And is the calculus of probative value versus unfair prejudice, which one outweighs the other? So every single piece of evidence, you're going to have to go through this to some extent, these processes. The most relevant pieces when you're thinking about tech evidence are authenticity and the originality piece, as described above. So,
Ian,
yeah.
I just wanted to comment okay, maybe you're going to get into it under hearsay here.
You can go ahead, jump in.
I was just going to insert a quick comment. You hear a lot about hearsay, and it is often a reason things like letters from friends or family who may have seen an incident are not accepted because the person's not in court there to take questions about what happened. But when it comes to tech evidence, hearsay often doesn't matter as much because you're not necessarily seeking to admit it for, say the text that you want to get admitted says something like, you and the kids aren't going to make it through the night. You're not trying to admit it for the truth of you and the kids really aren't going to make it through the night. I mean, although obviously that's the fear that is intended to be caused. All you're trying to get it admitted for is to show that it was said, that there was this threat made. And so hearsay doesn't even come into play. And that's an important distinction to keep in mind for a lot of what you are looking to admit for tech evidence.
Thank you. That's a great feedback. And the truth is, there's oftentimes in the tech evidence context going to be, even if whether the question that I think Amanda just presented, which is important, which is that oftentimes you don't actually even have to get into a hearsay analysis to some extent, because you might not be offering it for the truth of the matter asserted. But even if you are, there is oftentimes a hearsay. There are exceptions to those rules, and I think the biggest one in the tech context is admission by party opponent. You're oftentimes, sort of saying that the other person in the case is the one who said it, which can help you get around a variety of hearsay issues. But there are a couple of other hearsay options that come up. I did just see a quick comment in the chat box that I wanted to bring to everyone's attention really quickly. So it says, you suggested that keeping phone numbers to consider receiving text can sometimes have, sort of a protective factor. That this person suggests that getting a new phone in case the abusive person or a dangerous person has a way to track the old number or the old phone. And could I speak a little bit to how keeping phone would mean that that the person could potentially be surveilled? So it's a great question. Thanks for bringing it up. I don't want you to leave with the idea that keeping the technology and keeping a phone number is always the safest way to deal with it. It's not. Every case is going to be different. And I think it's really important to think through with the survivor their own particular needs. So I don't want to suggest that that's a cure-all by any means, because it's not. But there is a really good point here, which is that there are things like spyware. There are a variety of different ways that people can be that can track and utilize technology to continue to surveil. As an example, we work with Cornell Tech in New York, and they have a couple of professors and a couple of PhD students who are doing some work right now on the issue of spyware on mobile devices. So spyware in the traditional sense is something that will allow you to essentially see everything that's taking place on the other person's screen. While spyware on mobile devices is definitely a big concern, and it does pop up sometimes, it's actually not. It's a little bit more complicated than, say, spyware even on a computer in a couple of different ways. And so even if it's not a traditional spyware where you can see everything that's happening on the other person's phone, there are a great number of sort of dual-use applications, so things that may allow a person to track some aspect of the other person's device. So, my earlier suggestion about learning what plans the people are using, what devices they're using, what social media things that they have accounts with, all of that stuff is how you really sit down and come up with a plan about whether or not this is a case in which you think, in which there's some indicators that surveillance and tracking is of issue. And so there may be times in which getting rid of a phone is the best option. The hard thing, and Tracy brought this up in a moment on the chat feature, and it's really a great point, is that once something like spyware is accessed on devices, the way that we generally store information nowadays is through the cloud, which means that you not only have to get rid of a device, you not only need to probably get rid of a phone number, but you need to get rid of all of the other things that are linked to that account, because information can be stored through the cloud and can be accessible in that way. And so if it's cases in which you think the person is being tracked or located, you definitely need to think through whether or not getting rid of that device is the best option. Also need to think through whether getting rid of that device is going to alert the other person, and whether that's the alerting is going to put the person in further danger. So I think there's a lot of considerations there, and if you do in fact think that there's a spyware issue, we're really or other type of location tracking, we regularly talk to people and are happy to think through those issues. And there's a lot of considerations to take into consideration there, and we're happy to help you through that process. But true traditional spyware gets really, really complicated. The other circumstance that I did want to just bring up is that many people, for a variety of reasons, and this has become easier and easier as time has passed, have shared plans, shared cell phone plans. So many people are on family plans, and that's financially makes sense for people in many circumstances, but there is a ton of information that one person can get about the other person if they share an online account in that way. And so, it is really a good idea to know whether there's a family plan, what information is being shared, whether they know it or not, whether there are online accounts like their cloud-based storage accounts, and there are other syncing functions on the phone, whether all of that is easily accessible by the other side. They're, going through and thinking through their security, like I said earlier, is extremely important and really should be considered an aspect of tech evidence collection, because without security on the device, you essentially lose all of the benefits of the evidence. So thanks. I'm glad you all are jumping in on the chat. We'll continue to move forward, and I will try to respond as necessary. When dealing with tech evidence and admission of tech evidence, what you definitely will see is that oftentimes defense attorneys will try to push back and say, well, how do we know that this evidence wasn't altered? How do we know it wasn't photoshopped? And the thing is, be prepared for it. Know your case law in your state. If you're an attorney, help survivors plan for that to some extent, if at all possible, because it does pop up. And what you want to be able to say is that it's not enough from an evidentiary standpoint to say that something could be altered. You need something more than that in order to exclude it. You need to show that there's some indicator that it was in fact altered. Because the truth of the matter is that there's nothing about tech evidence that necessarily makes it any less reliable than any other type of evidence in terms of modification and changes, right? That, in fact, in some ways it has a higher indication of reliability because you oftentimes will have metadata that can show whether or not something has been modified or not. Which is something that's not necessarily present in other contexts. So metadata saves different copies of things, and somebody who's skilled in forensic analysis can oftentimes see every single time there's been any modification of a particular piece of online information, and that can be a great indicator of something's reliability. So claims of alteration need something specific. It's not enough to just say that it can be changed. The truth of the matter is that testimony, people talking about what they saw, what they heard, what they experienced, is also very easily altered and modified, and yet is the type of evidence that's oftentimes given the most credibility. So all evidence can be modified. When thinking about messaging evidence, here are the things you're mostly going to see: screenshots or digital photos. Those are by far the largest. But if you do have cases in which the person has accidentally deleted something, or some other way a text message or another type of message has been destroyed, there are other options in order to retain it. It can be harder to get it in. So my suggestion is to take a screenshot. Keep it on the device if at all possible, and if we're dealing with like a text message, for example, also get the records from the phone company, and the records again are not going to have what was actually in the text, but they will have that something was sent or received, and that can be really helpful to compare and contrast it with the timestamps that we referred to earlier. Who are you going to think to authenticate? You can have anyone who saw it, who sent it, or who received it. Sometimes business records are also available, but usually you're going to have one of those people testify. In thinking about authentication, we talked about this earlier, that distinctive characteristics like that one space before the period can be really useful. Other types of characteristics might be the way that people communicate, the types of words that they frequently say, the type of information that they refer to. You can oftentimes get tech evidence by contextualizing it. So somebody will frequently refer to either something upcoming or something already past. Those references can be a great way to contextualize it. You might be able to compare it to other things that have already been sent. Example, the case where I had the extra space before the period. Part of what we did is we compared that to several years of emails that had been sent from the person's email address, and we were able to show that there was similarities between those two things, and that was successful in court. When somebody replies or responds or acts in a way that's consistent with something in a message, all can be really, really great ways to get that information authenticated. For social networking evidence, you're going to have something quite similar. Basically, you want to show that whatever you're presenting to the court is an accurate depiction of what was on the website or on the screen, and that the content is really attributable to the owner. Social media postings can be hard to attribute at times to the owner. So what you oftentimes require are circumstantial evidence. That can be photos that identify the person, other types of personal information, printouts that has usernames or profiles, some other examples of things that people have been successful with. It's really good idea to look at the time period that a social media account has been open. If you have something that's been around for 10 or 12 years, people oftentimes, or a longer period of time, people oftentimes have been communicating with others for a long period via that mechanism, and so you can have people potentially like a third party who's not necessarily connected to the case testify for the sole purpose that they have actually communicated with that person at that site and know it to be them. The survivor themselves can also oftentimes testify to that as well. But there's a ton of good circumstantial evidence that can be presented in there, and so it really takes looking at it in the keen eye, looking at the friends that they have, how long it's been around, and what else has been done through it. So we're closing in on our time. I see a couple of questions, and then we're going to get to resources. But I do want to open it up. If there are any questions, please continue, and we'll go through resources while people are asking chat. I did see one here that says, why does law enforcement not want to prosecute spyware downloaded on child devices altered? So, well, no way to effectively answer that question, I don't think. from this side. I do know that spyware cases are extremely difficult to prosecute for a variety of reasons. So traditional spyware is what's called a ghost file. It can be hard to even locate on a device. A ghost file is something that lives in the background and isn't necessarily easy to see even when you open up what programs are doing. So I think that there is a challenge there to begin with. I think there's also some serious issues when we talk about children and whether or not there are what parents' rights are in terms of their ability to monitor their children's whereabouts and what's going on in their devices. I think that's a challenging legal issue that still yet to fully and clearly identify what the limits of these things are. What I will say is this. That situation is such a great example of one thing that we don't have time to really get into today, but is really important, which is, when you're crafting and you're asking for things from the judge around specific types of behavior that can be included in civil protection orders, criminal protection orders, or in custody orders or other court orders, it's really important to be specific about the things. So, for example, an abusive party. Now, again, I don't know the circumstances of this case, but if the abusive party has demonstrated that they are misusing technology in a variety of ways, it can be really useful to ask the court from the beginning to have certain prohibitions on actions and behaviors and what they can do, including on things around monitoring the children's devices. And doing that in advance, putting it in, can both serve as a deterrent, but it can also serve as a really important mechanism of holding people accountable in areas of the law where you don't necessarily always have clear answers. So I see a couple of questions still popping up. I'm going to keep going. I do want you all to know that in addition to the materials, and I did see a couple of questions pop up here, we do have the 2 resources referenced, and we also have the information for this webinar are uploaded onto the materials that you can all download yourselves. Should be underneath the chat box. Amanda, do you want to talk really quickly about the annual conference?
Yeah, just really briefly, our annual conference is coming up next month in Denver, Colorado. We've got a ton of information on domestic violence and family courts and child and abuse and neglect and juvenile courts. So if you have any interest in any of those things, we've got like at least six tracks, and there would be something for you.
Great, thanks. Andrew did ask a question regarding safe places to store evidence, particularly where you have a survivor who's still living with the abusive party. I will tell you this, there are a lot of free or low-cost cloud options that can have some safety features that are strong. You want to think through ways to make sure that the device itself is not necessarily directly linked to the cloud-based service, because that, particularly where somebody is still living with the person, it can be hard to fully protect that device from that person, and if there's a link, then you've sort of lost your safety mechanism there. But I will say that we oftentimes have people who are using free cloud-based services like Dropbox to save certain types of evidence with requisite levels of privacy and security, basically making sure that passwords are safe, adding in different levels of two-step authentication where necessary, and that's not going to necessarily be clearly identifiable. Many times people will store that evidence with friends and family. I will say I really push back against people doing that, because I've had way too many cases in which somebody was extremely sure that a family member or friend was going to be willing to testify on their behalf, and then when the time came to do so, they weren't willing to do that, or became not as useful, not as helpful, and they were unable to get their information. So cloud can be good, flash drives can be good. We sometimes will have individuals who will store things in flash drives and then store it in a safe place in the office of their attorney. Those can all be kind of options that might be useful to people.
Okay.
Great. So, yep.
Sorry.
Yeah, so there are a couple of other resources here, and that we hope that you all spend some time looking through. And if you do have any questions, of course, our RCDB and NNEDB both are accessible and available for you. Here's my information, and I'll pass it back to Amy. Thank you all so much for your time and your feedback on the chat. Amanda, do you want to close this out?
Okay. Yeah, sorry. The audio cut out for somebody, and I wasn't sure if it was for everybody. Just real quickly, here are the other two guides that are currently available in the SRL Guide Series. They're available on our website, rcdvcpc.org. I'll put that in the chat. We've got some more in development. If you have ideas for topics that would be useful to self-represented survivors, please let us know. We are always looking for new topics. And if there's any other way we can help, here's all of our contact information on this slide. And please feel free to contact us. And thank you so much for joining us today.